Senator from Richland, Senator Harpootlian, what purpose do you ask?
Sure. A couple questions.
Sure. Senator yields for question.
I am intrigued by the example you used of the truck that pulls over on the side of the road. Now, did the truck cause everybody's injuries? Let me suggest to you that it did. And let me suggest to you why. The reason why is section 56-5-5090, which says whenever any motor truck, tractor trailer, is disabled upon the travel portion of a highway or the shoulder thereof, outside of any municipality or any time, they must put a lighted fuse shall immediately be placed on the roadway at the traffic side of the motor vehicle, and other all kinds of things, flares, signs indicating this is a disabled truck. So this truck did, based on your example, violated the law by not giving notice, hey, I've got a disabled truck here, which would have let that vehicle that was passing him know something bad happening here, maybe I ought to slow down, watch a little bit better. And the vehicle pulling out would have been put on notice as a disabled vehicle there, and this is a dangerous situation. The truck caused the wreck, did it not?
Senator, I don't disagree with you that there's some fault on the truck.
Some? Would it have been a
We
wreck
had
if
somebody who pulled out in traffic without having a good view. Now, you and I both know that that also is a violation of a statute, right? The truck by himself did not cause this. I will concede to you that the truck contributed. There's some amount of fault on that truck, but there's also some amount of fault on the guy coming out of the parking lot.
Well, isn't the truck allowed to argue to the jury that this person that pulled out was at fault?
Of course he is, but as you very well know, you've got to persuade, the jury has to believe that that person was completely 100% at fault.
What if
Because if he's not 100%, and there's nobody else to apportion it to in this situation, which is exactly what happened in Smith versus Tiffany, that you can absolutely argue, yes, the guy pulling out of the parking lot should be here. But if the jury believes that the tractor trailer was negligent at all, and based on your reading of the statute, which I do not disagree with, there is some liability there, they're then going to have to put 100% liability on that truck.
Well, how about do this then? Let's tell the jury how much insurance that vehicle that settled paid or had, and let's tell them how much insurance the truck has. Let's let juries know how much insurance is at play here. What about that?
Well, I don't care.
You don't?
I don't care a whole lot about that, but I'm not going down the rabbit hole. That's not the issue.
It is the issue.
It's not the issue. The issue is, should a jury be able to apportion fault among all the tortfeasors?
How about based upon the ability to pay?
Should the jury apportion fault among all the tortfeasors? That's another step, and you know that very well. That's another step that's later on. The issue right now
that's a step you would be willing to take?
The issue right now is, should the jury be able to apportion fault among all the people who caused harm? That's the question.
That isn't exactly the question. The question is whether or not a grossly negligent truck driver who violates the law shouldn't bear more of the responsibility. Now, let me say this, or should not bear 100% of the responsibility. I think that a truck driver that violates the law should bear 100%, and that's what we're really talking about. And also we're talking about, in most instances, if the jury knew that the settling plaintiff, all this is going to mean is that nobody ever settles with those plaintiffs. More people are sued, more litigation. You and I make more money in our chosen vocation. But this is a way, and this is the way the statute was written. This is the way the Supreme Court's interpreted it. And who gets the benefit of this? The defendant tortfeasor who has the best ability to pay wants to shunt some of that off to somebody else who doesn't. I
think that's completely incorrect. Look, I think that the truck driver, I think the truck should pay, but I think the truck should pay for what he caused. I don't think that now see, what you're talking about is actually another part of the bill that I haven't gotten to yet, but I'm happy to talk about it. You're talking about Section F, right? I haven't gotten to Section F yet.
Well, no, I'm talking about, you're talking about the empty chair.
Well, that's part of it.
Right.
But I think all the tortfeasors, the jury ought to be able to apportion fault among all the people who cause harm.
And
They ought to
if
be
you're
able to do
going
it.
to do that, they ought to have some idea of the party's abilities to pay. In my view, if you're going to take that step, if you're going to start amending the law, why not go ahead and do that?
Well, and I appreciate the view. I don't know that I agree with you, but I'm also not going to go down that rabbit hole. The issue is, should the jury be allowed to apportion fault among all the tortfeasors?
And I'm saying I might agree with you if you'd let them know who has the ability to pay, let them know what their insurance coverage,
that's irrelevant to whether they're at fault or not.
Well, it's not irrelevant as to whether.
Absolutely
No.
is.
You're talking about apportioning fault. You're talking about changing the statute to allow fault be apportioned to somebody that's settled. Once you go down that rabbit hole, if you will, then we ought to give the jury more information. Why do we not want the jury to know? Why do we want to create this fiction? I mean, you're talking about fictions.
I don't know that I really care about that again, but I will say that's not the issue. The issue is, should they be able to apportion fault among all the tortfeasors?
Framing the issue is how you win this. If you would allow other things to be considered, you may not get the whole cake, but you get a piece.
Yeah, maybe, or I don't know that's everything that you consider. I think elections also have consequences. So we'll see, right?
Are we voting on somebody in here today? I'm sorry. We just filed.
Look, you've kind of brought up Section F, and I'll say this. So the way the law, and you know this, but speaking to everybody else, historically in South Carolina, we had pure joint and several liability, right? Which means that you're liable you could be 1% responsible, and you could be responsible for the whole verdict because you've got the pockets. Now, in 2005, that was changed. It modified some. The Senator from Darlington talked about this, but it modified some, and it says there's joint and several liability only if you're over 50%. But, of course, it was a trick because you're always going to be over 50% in this statutory framework because you can never consider the other tortfeasor. So there's only one defendant. You got to be over 50%. All right? So that's a problem. But it allowed, what this does, Section F, is it says if you are reckless, you don't get to take part, you don't get to benefit from any potential benefit of a modified joint and several. It says if you're reckless, you can be responsible for all of it. You may have just done 10%, but you could be responsible for all of it. I think that's wrong.
Well,
it says that if you sell alcohol,
yes,
that you could be responsible for 100% of the damages, even if a jury thinks you only contributed 5% of the injuries. I think that's wrong. I will tell you, Senator, I don't like this bill. I don't like the 2005 law. I don't like joint and several, period. I think we ought to abolish joint and several entirely. In fact, there may be an amendment later to do that. I think we ought to wipe it out because I think you should have to pay for the damage that you cause. You should not have to pay for damage that I cause. Right? I think joint and several is patently unfair. Right? We should abolish it entirely.
Well, what would you say to the victims of a felony DUI? I have one right now where 2 killed, 1 wounded by a drunk driver.
Yeah.
What do you say to those folks when the drunk driver has $25,000 in coverage and the bar has $1 million in coverage? Why shouldn't that alcohol exception apply? Tell me why we want to reward bars that overserve.
It doesn't reward them. But what the situation is now is you're going to put 100% liability on somebody who may be 10% responsible, and you excuse, in many cases, the other person. Right? I mean, what the law now allows is, and this is the way that it practically works. If somebody were to go to a restaurant and you have a drink, and then you go out and you hurt somebody, right? First of all, I think that person ought to get hammered. I think our criminal laws on DUI are too weak. I think we need to do a much better job of strengthening those laws, right? I think we need to be harder on the businesses who sell if they actually did something wrong. I think we ought to yank their licenses and not let them sell alcohol anymore, all right? But if they are 10%, if that restaurant was 10% responsible,
how are they 10% responsible?
Well,
If they overserved somebody and put them out of the place
but
drunk.
maybe they did. Maybe the person didn't appear to be intoxicated. Maybe he wasn't slurring. But look, here's what's going to happen, and you know this is true. That restaurant is going to get sued, or they're going to get sued regardless.
You can sue anybody.
Absolutely, but they're going to get sued regardless. And the way this law is written, you are forcing them. I mean, they're in a situation where they're going to have to pay all their coverage, even if they were only 10%, because they can't take the risk of going to trial and being the only defendant there, and as soon as they're found to have any type of liability at all, even if you put the drunk driver in there too, and the bar would only be 10% liable, if the jury decided whatever under the fact pattern, that the bar is really only 10% liable, or heck, even 40% liable.
Give me a fact pattern where they're 40% or 10% liable. Give me a fact pattern.
I don't know, but that's for a jury to. That should be for a jury to decide. Let the jury hear everything, and then let the jury make the decision.
But what you're trying to do is insulate bars that overserve drunk drivers. I'm not trying to insulate them.
No, I'm not trying. What you're doing is you're rigging it against them because they got money, right? But well,
by the way, if you had seen as many victims who lose their children, lose their breadwinner, do I want them to get a lot of money? I do. Do I want the people who are selling that poison, overselling that poison,
pay? Let's close them down.
I do.
Let's close. Look, it suits me. We put those people in prison.
I've closed more bars, participated in closing more bars than you ever have, and I can tell you right now.
I'm not fighting you on that. All right, but here's my problem. They ought to have to pay for what they caused. They should not have to pay for what they did not cause. I don't care how egregious the conduct is. Right? However egregious the conduct is, I should not be responsible for more than what my conduct is. Right? I don't like joint and several at all. I think it is patently unfair. Now, in your situation, in the situation you brought up, there may be, the drunk driver may not have very much insurance coverage, may not have sufficient amount of insurance coverage to cover what all the damages are.
They never do.
That happens oftentimes. Now, I don't disagree with that. That is an injustice. But I will tell you that you don't address that injustice by creating another one. And that's exactly what this does.
Who created the drunk driver? The bar.
The drunk driver.
Well, okay, I'm sorry. So we're going to insulate bars from overserving.
No, if that's the case, right?
Civilly.
Well, that's fine too. Look, if this guy is in the bar and he can't even stand up, or if it's not even that bad, right? If he's clearly intoxicated, if any reasonable person could look at this guy and say, all right, he's intoxicated, he shouldn't have been served more, right? Then in that situation, it may very well be that the bar is more than 50% liable. It may be that the bar is 90% liable. Now that's a hard one for me to believe because the fool still did get out in his car and drive. But still, if that's the case, if a jury believes that the bar's conduct was such that the bar was 75% responsible, make them pay 75% of what the damages are. I'm okay with that. I think that's the way it ought to be.
My position is you walk into the bar, you order 4 vodka shots, they serve them to you, and by the way, you walk out 30 minutes later, you appear to be sober, but 35 minutes later, you head on a mother, a child, and kill them. Yeah. Now, who is 100% at fault for that? Now, again,
I think in that situation there is no one person is 100% at fault.
Well, this is where we're going to disagree. I think the bar should take, because they're making a profit off of.
You don't think that the guy who drank the shots, who then walks out and gets in his car and drives and actually does the deed is responsible at all?
Absolutely, he's criminally responsible.
You just said it's 100% on the bar.
Well,
and it can't be.
Under my scenario, you can sue both of them or not sue both of them. That's up to the victim to determine who to sue and who not to sue.
I understand. Look, and I don't care who you sue, all right? But you shouldn't get to apportion all the fault against a person who's not responsible for all of it.
If the drunk driver's there with the bar, the jury can apportion that. We're talking about a situation
let them in.
What?
Right? Let
they
the
can
jury
do that right
know.
now.
Let the jury consider the drunk driver's culpability.
And that to deflate culpability from the bar that overserved
the
him.
The bar then, the jury is going to decide how much responsibility the bar has, and the bar must pay that amount of responsibility.
Look, I have the greatest faith in juries. I have stood in front of juries and asked them to kill people, okay? And they have done it on occasion. I have great faith in the jury system, but this is creating a fiction. Now, if they know that drunk driver had a $15,000 insurance policy and that bar had a $20 million insurance policy, then I think they ought to be able to apportion.
It's not creating a fiction. This is addressing a fiction. Right now, it's a fiction because they're not allowed to consider everybody who contributed to the fault.
Well, one man's fiction is another man's truth, apparently.
Well, I mean, this is ensuring that the jury can deal with all that.
So I'm not going to convince you here, huh?
Convince me, no, and I'm not going to convince you.
No. Thank you.